What's going on, everybody? My name is Andrew, and today I'm here with Costas, and we want to talk to you about what it is that you do if your tenant tells you that they have not received the legal documents that either you served to them or that the LTV was supposed to get to them. So let's get into that right now. So today we have an email from Kevin out of Toronto. He is a landlord managing a triplex, and he says that his tenants did not show up to their hearing date, and they said that they did not receive their N form, nor did they receive the forms from the LTB with their trial date. What is it that you can do to make sure that this excuse doesn't fly? So this is something I think that happens very commonly. I mean, we've dealt with tons of rental properties, and we have a lot of tenants that we're just gonna have to serve routine forms. Like we serve N4s like there's no tomorrow, and that's just because of formalities. You know, people do pay their rent more often than not. However, we always make sure that we serve these forms. Now, obviously, it's very easy for somebody to say that they didn't receive the form, but there are certain things that we can put into place to just reduce the likelihood of that being believed, right? And we want to talk about the evidences. So what does it cost us that that is done when you serve, let's say, an N4 as an example? What is it that happens to make sure that you can officially say, I've served this person, and to support it?
Well, usually what you would like to file with the N4 after serving the N4 is the certificate of service. That kind of validates that you've actually pushed out that N4, but there are other things that you want to do as well, right? So you want to communicate with the tenant that you've gone ahead and then you've submitted the N4. You want to do that by communicating that via email, or you want to get on the phone with them and tell them that you've done that already. You just want to be vigilant when you're doing these things, and you want to, cover all your bases so that you're not found in a situation or predicament where the tenant says that, hey, I didn't receive this, right?
Yeah, but they can always say that though, that's the thing, right? So and then it ends up being your word against theirs. So as much evidence that you can have through either emails, the certificate of service, texting to support that you did everything you could possibly do to make sure that they are aware of this, it would just reduce the room for guessing or the adjudicator wanting to give the tenant the benefit of the doubt, right?
Well, yeah, and it also puts you in a better place, puts you in a more favorable place, because you've done everything in your power to ensure that you've communicated the fact that, hey, listen, I've sent over this N4, you're aware, right? So it's just about, like I said, it's, dotting your I's and crossing your T's, just to put you in a better place.
Yeah, actually, and this is one of the things that we always talk to landlords about is actually documentation. We're very big on documentation because it is what separates a professional landlord from an unprofessional landlord. Somebody who makes sure that they are always tracking everything they do. Actually, just something that I think is always very interesting that people don't know in Ontario is that you can actually have your conversations recorded on your end as long as one party knows that they are being recorded. And we often have that, not because we necessarily need to use it, but it's just if it ever comes down to anything serious and they say, oh, we never told them, it's come in handy so many times that we're able to say, listen, we said this and this and this, and now they're saying that we didn't tell them this, and we have evidence to support contrary to that. So it's good to have this. Now, you don't have to go that far as to record your conversations, but at least basic things, text, emails, anything that you can always show to an adjudicator and say that I did everything the way I was supposed to. So, I'm working professionally here, so let's work together, right? But now's the question, if a tenant does say that they didn't receive documents, what do you think an adjudicator is likely going to do if they say that they didn't do this?
I personally think they might give them a break if you don't have sufficient evidence to support your position.
Yeah, I mean, even sometimes when we do have all the evidence, they still give them a break, right? Because I mean, it's the disposition of the LTB is really to keep people in their homes, which is not a bad disposition, right? And there are a lot of landlords out there who will go and say that they did all these things. How we've even heard of landlords who have gone and intercepted the LTB forms from the mailbox. And yeah, you're not allowed to touch people's mailboxes and take their mail. That's illegal, of course not. Right? And people will go through weird measures to do this, right? And then somebody's getting kicked out of the home, and it's not right. But at the same time, as landlords, we need to raise the standard, and we need to make sure that we're doing things properly and professionally.
It's always best practice to just make sure that you cover your bases and put yourself in the best possible situation, given that you find yourself in a circumstance like that, right? You don't want to be left without any reference points or evidence or anything to prove your point when it comes time to appear before an adjudicator.
Yeah, and by the way, one thing that we want to end this with is that sometimes if even if somebody is saying that they haven't filed the forms, you always need to make sure to take a swing. A lot of paralegals, especially if you're paying them, if they feel like they don't have a strong enough case, they will choose to withdraw because they even have like their own reputation that they want to uphold. They don't want to go in and look like they're going in on a case that isn't filed correctly. So if you're hiring somebody, they might do that. But oftentimes, honestly, in my opinion, as opposed to withdrawing the case, I always prefer to go there and see if I can have it explained. Because honestly, if they don't show up to the hearing anyway and you get the ruling, it's better than not. Even if something was not done correctly, always work with what you got. If any of you have any questions about an LTB matter or how to approach certain situations, do make sure to reach out to us, and we'll leave some information about us in the description below. In the meantime, make sure to like our video, subscribe to our channel, and we'll see you on the next one.